أكبر الله أكبر الله أكبر الله أكبر
পিতা পুত্ৰ পবিত্ৰ আত্মাৰ নামত আমিন
হস্পিটেলত টেষ্ট লাগে কোনোবাই দিব
ময়ো দিম
লা 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 লা
ধুক 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 ধুক
মই ক'ত আছো
হস্পিটেলত
মোৰ কি হৈছে
আপোনাক টেষ্ট দিবলগীয়া হৈছিল
টেষ্ট 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 কোনে দিছে আপুনি
মই দিছোঁ
আপুনি
ময়ো দিছোঁ
আপুনিও আপোনালোকে মোক কিয় টেষ্ট দিছে
ডাঙৰীয়া তেখেতসকলে আপোনাক যদি টেষ্ট নিদিলেহেঁতেন আপুনি পৃথিৱীত জীয়াই নাথাকিলে হয়
কিন্তু
কোনো কিন্তু নহয় আপুনি চব ভুল বুজি আছে
ডাঙৰীয়া তেজৰ কোনো জাতি নাই ধৰ্মও নাই বুজিলে তেজৰ ৰং এটাই
ৰঙা
লা 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 ব্ৰেকিং নিউজ আজি 14 বছৰ সশ্ৰম কাৰাদণ্ড কাটাৰ পিছত মুক্ত কাহৰ তলত নিৰ্মল কলিতা ওলাই আহিছে হয় এইজন নিৰ্মল কলিতা হয় আপুনি কওকচোন আপুনি জেলত কি থৈ আহিছে আৰু বাহিৰলৈ কি লৈ আনিছে
মই মোৰ মনৰ বেয়া ভাৱনাবোৰ বেয়া চিন্তাবোৰ এৰি থৈ আহিলোঁ আৰু মানৱতাবোধ বুকুত কঢ়িয়াই লৈ আহিছোঁ
বিগ ব্ৰেকিং নিউজ মানৱতাবোধ জেলৰ পৰা মুক্ত কাহৰ তলত বুকুত ঘূৰাই লৈ আনিছে হয় আপোনাক কওক যে আপোনাক এতিয়া কেনেকুৱা লাগিছে
মোক এতিয়া সম্পূৰ্ণ নতুন লাগিছে মই এজন নতুন মানুহ
লা 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 লা
Artist. Your performance is a testament to your commitment to reformation and a brighter future. Ladies and gentlemen, we will begin with the main event in a very short while. I request our guests to kindly remain seated. I request the members of registry to kindly escort our dignitaries onto the dais. Ladies and gentlemen, I am delighted to announce the arrival of our chief guest for today, Honorable Mr. Justice Uday Umesh Lalit, former Chief Justice of India. We also have with us Honorable Mr. Justice Sandeep Mehta, Chief Justice, Gauhati High Court, Honorable Mr. Justice Sanjay Medhi, Judge, Gauhati High Court, and Honorable Mr. Justice Manish Chaudhary, Judge, Gauhati High Court. As the Honorable Gauhati High Court completes its 75th year, we are celebrating this milestone with a series of events. Today, we are privileged to have amongst us our chief guest, Honorable Mr. Justice Uday Umesh Lalit, former Chief Justice of India, who will be enlightening us all by delivering a lecture. But before that, we would like to felicitate Honorable Mr. Justice Uday Umesh Lalit, former Chief Justice of India. I request Honorable Mr. Justice Sandeep Mehta, Chief Justice, Gauhati High Court, to kindly do the honors. Thank you. We would also like to felicitate Honorable Mr. Justice Sandeep Mehta, Chief Justice, Gauhati High Court. I request Shri Gautam Borua, Registrar General, Gauhati High Court, to kindly do the honors. Thank you. We would also like to felicitate Honorable Mr. Justice Sanjay Medhi, Judge, Gauhati High Court. I request Roman Borua, Registrar Vigilance, Gauhati High Court, to kindly do the honors. We would also like to felicitate Honorable Mr. Justice Manish Chaudhary, Judge, Gauhati High Court. I request Srimati Kanchan Newar, Secretary, Gauhati High Court Legal Services Committee, to kindly do the honors. Thank you. May I now request Honorable Mr. Justice Sanjay Medhi, Judge, Gauhati High Court, to kindly deliver the welcome address.
Namaskar and a warm welcome to all of you. When one enters the main building of the old block of our High Court, one would notice a plaque regarding the opening of the building. It was opened by Sri Govind Ballabh Pant, the then Union Home Minister. A minute observation of the plaque would reveal that something has been removed from the same. The plaque had the words Bharat Ratna prefixed before the name of Sri Pant. However, on his instructions, the same were removed, but the smudges are still visible. The purpose of narrating the above story, which is a part of the history of our High Court, is that today we have amongst us a personality whose values are no less. Honorable Justice Uday Umesh Lalit, who retired after adorning the highest seat of the Indian judiciary. Can we have a big round of applause for Justice Lalit? Justice Lalit has the unique distinction of practicing as a junior counsel under the great Soli Sorabji in the Supreme Court. He was an advocate on record in the Supreme Court. He was designated as a senior counsel in the Supreme Court, and he was amongst the very few to be directly elevated to the Supreme Court from the bar. I have seen Justice Lalit as a senior counsel who was known for his impeccable quality and simplicity, and in the prevailing jargon in the Supreme Court at that time, he was one of the counsel who would be engaged to bring a matter which had gone off track back to track. During his tenure as a senior counsel in the Supreme Court, he was entrusted the task of being the special public prosecutor in the 2G case, which was a mammoth trial having voluminous records, and this was only because of his impeccable integrity. As a senior judge of the Honorable Supreme Court and as the chairman of the National Legal Services Authority, the steps taken by him in the service of humanity are almost unparalleled. He started the concept of LADC, the Legal Aid Defense Council system, which is benefiting most of the underprivileged. And I can inform you, sir, that in 17 districts of Assam, it has already started, and the rest are in process, as well as in the other states of the Northeast India. During his tenure, the number of disposal in the local adalat has been outstanding and almost unparalleled. As the Chief Justice of India, though for a short stint his contribution is immense, the Honorable Supreme Court had begun the live streaming during his tenure for public view, for making the judiciary more transparent and accessible to all. His role in reducing dependency is praiseworthy. He has delivered and has been part of a number of landmark judgments. Sir, we are indeed fortunate to have you amongst us today. I welcome all the dignitaries on and off the dais. Retired judges of the High Court. We have Justice Ujjal Bhuya, the Chief Justice of Telangana High Court. Their spouses, my brothers and sister colleagues, senior advocates, members of the bar, learned judicial officers and staff of the registry, media persons who is covering the event, and all those who are connected with the Platinum Jubilee celebrations to today's function. We are all eagerly waiting to be benefited by the address of your lordships on the topic concerning rule of law. I once again offer our sincere gratitude to all of you for being a part of this celebrations. Thank you.
Thank you, Lordship. May I now request Honorable Mr. Justice Uday Umesh Lalit, former Chief Justice of India, to kindly deliver his lecture on the topic Constitutional Vision of Rule of Law, a Citizen's Perspective.
Honorable Mr. Justice Sandeep Mehta, Chief Justice Gauhati High Court, Honorable Justice Ujjal Bhuyan, Chief Justice Telangana High Court, all the honorable judges of the Gauhati High Court, senior advocates, junior counsel, and everybody who has at some stage or the other was associated with the journey of 75 years of this High Court, persons from the print and electronic media, ladies and gentlemen. It's a very onerous task to be delivering an address on rule of law, which is so dear to every one of us. The dimensions are unfathomable, and to be trying to go anywhere near that concept in the shortest possible time of half an hour is a very Herculean task. Very well, let me begin, and I'll just place one or two judgments of the Supreme Court which had the occasion to deal with the concept of rule of law and how the matter was assessed by those two judgments. Both are Constitution Bench judgments. The first one is KT Plantation, which was the bench presided over by Justice Kapadia, but the judgment is authored by Justice Radhakrishnan, and the second by Justice Bhagwati, who was presiding as Chief Justice, and the judgment in Sampath Kumar. And the third one, of course, is a celebrated judgment of Justice Bhagwati again in P. Sambamurthy. And then let me just then develop the point on rule of law and just place it for your kind consideration. What could possibly be the parameters or the diameter of this entire concept? In KT Plantation, the observations by the Supreme Court go to the extent of saying the rule of law as a concept finds no place in the Constitution, but has been characterized as a basic feature of the Constitution which cannot be abrogated or destroyed even by the Parliament, and it binds the Parliament. Next sentence, the rule of law affirms Parliament's supremacy while at the same time denying it sovereignty over the Constitution. Just mark the sentences. First and foremost, that rule of law has now been characterized as one of the basic principles of the Constitution. We all know the dimensions of, once you characterize or once you put it at the level or at a stage when you call it a basic structure, what does it imply? Going by the law laid down by the Supreme Court in Keshwanand Bharati, any violation of basic structure or any principle which is part of basic structure can be a ground on which even a constitutional amendment may also suffer the, perhaps I think, the wrath of the Constitution Bench of the Supreme Court and can be invalidated. This is, of course, the general perimeter of the matter which has been described in this judgment. Now let us see Sampath Kumar. This judgment, KT Plantation, is quite recent in time. Sampath Kumar is 1987, and the same bench dealt with two matters. One is Sampath Kumar and the other is P. Sambamurthy. Sampath Kumar, of course, every practitioner who has been practicing law knows that the validity of Central Administrative Tribunals Act, as well as the provision in the Constitution which empowered the Parliament to enact a legislation such as that, was under challenge. The bench of 5 judges went to the extent of saying that because the amendment created an alternative institutional mechanism. Therefore, even if the normal jurisdiction of the High Court under 226 could to a certain extent be excluded, the amendment would not invite the final sort of declaration that it violates the basic structure. So the amendment to that extent was saved by bench of 5 judges. Of course, it's a part of our constitutional history that 7 judges bench later, which is L. Chandra Kumar, took a different view and went to the extent of saying that 226 itself being part of the basic structure, judicial review, which denotes that. So the act could not have excluded the jurisdiction of the High Court. Of course, that's the constitutional history. What I want you to just consider these sentences which Justice Bhagwati stated in Sampath Kumar. And the sentences go like this. Judicial review is a basic and essential feature of the Constitution, accepted by the bench. It goes on to say, while describing judicial review, it says, it's a basic principle of rule of law which permeates every provision of the Constitution and which forms its very core and essence, that exercise of power by the executive or any other authority must not only be conditioned by the Constitution but also be in accordance with law, and it is the judiciary which has to ensure that the law is observed and there is strict compliance. Of course, they were dealing with judicial review, and one of the sentences goes on to say that this is actually part of rule of law, which permeates our Indian ethos or constitution. It is like saying that this is a golden thread which runs through almost every provision of the Constitution. The edifice is something which is built with this mortar called rule of law. What is rule of law? Then ultimately the next question. So one of the classic definitions which Aristotle in good old days had come out with, and according to him, rule of law is the rule of reason which entails that all public authorities and transactions should be guided by a rational argumentation instead of the whims of a few individuals. So all public authorities, their conduct, their business, public transactions must be guided by rule of reason, not whims and fancies. And that is exactly what Aristotle came out with this. Now, rule of law has thereafter gone through various kind of screening at every level. But coming back again to the point where I left, the third judgment, which is P. Sambamurthy. Ironically, what happened is the same bench which dealt with Sampath Kumar dealt with P. Sambamurthy. Sampath Kumar, the lead judgment is by Justice R.N. Mishra, supplemental note by Justice Bhagwati, and in Sambamurthy, the judgment of the court was delivered by Justice Bhagwati. In Sambamurthy, 2 provisions were under challenge. 371D, subclause 3 and subclause 5. Subclause 3 empowers the parliament or the state to come out with any provision setting up administrative tribunals at various levels, including tribunals for sales tax and other things. We are not on the subject of that particular amendment. Subclause 3, like the provision which came up for consideration in Sampath Kumar, again spoke of conferring jurisdiction upon the tribunal which hitherto before was exercised by courts other than the Supreme Court, which included the High Court. So the very same line, same thought, same submissions which were advanced in Sampath Kumar were being dealt with in Samba Murthy when it came to the validity of subclause 3 of 371D. Since Sampath Kumar the judgment was delivered earlier, their lordships rely on Sampath Kumar to reject the submission apropos 371D subclause 3. But there is another challenge which was apropos 371D subclause 5. And that said that any decision of administrative tribunal in terms of the power conferred under 371D, such decision could be revised by the executive. It virtually gave a power of veto to the executive over the decisions by the tribunal. So it created a hierarchy which was till then unknown, that is, a judicial decision could be subjected to further scrutiny or supervision by the tribunal. And this, Justice Bhagwati says, is a provision which is quite shocking. Why? Because he went on to say that rule of law, which is so fundamental and which is part of our basic structure, has one of its facets is judicial review. And such power of judicial review must be exercised finally by the constitutional courts. If you are creating a new substratum where the power which was until now being exercised by the High Court can now be exercised by the tribunal, you are creating alternate institutional mechanism, just as he accepted in Sampath Kumar. But on the very same analogy, the orders of the tribunal then must be given some kind of respect and at the same time must be held in highest esteem. Such orders of the tribunal being interfered with by the executive was found to be shocking by Justice Bhagwati. And on that touchstone, the amendment to subclause 5 was struck down in Samba Murthy. And the observation goes that rule of law being essential feature of the Constitution, that would include power of judicial review by the certain designated courts or tribunals, and any attempt where the executive, which could actually be one of the parties to the litigation before the tribunal, if you give that power unto that executive or that party to set at naught a decision rendered by the tribunal, that goes completely against the very basic ideas of administration of justice and rule of law. Why did I choose this particular case? The idea was to place before you the acceptance of the fact that rule of law, which the later judgment says it runs through your Constitution, it is like a basic idea which runs through the Constitution. If rule of law is taken to be so sacrosanct, even a constitutional amendment which seeks to impinge upon or transgress the boundaries of that can also be set aside. And this is a living example of that, where in P. Samba Murthy, Supreme Court set aside that particular amendment. What ultimately is rule of law? When we say that rule by, rather than individuals, we be guided by certain principles. Those principles must try to attain our constitutional goals, and that's where the citizen's perspective comes in. What, according to a citizen, would be ideal situation where legal principles or a codified law or the approach itself must be so sacrosanct that everybody considers it to be the highest goal and wishes to achieve that or to attain that. Our preamble says, we the people, so and so, we wish to have justice, social, economic and political. If that's the ultimate goal that we want to achieve, if these are the principles, then take those principles to be the highest achievable ideals and test everything on the parameter of those principles. That would be the citizen's perspective when he wishes to say that what is the constitutional goal and the aspirations under the Constitution. Where is the role of the judiciary in that? If you recollect the observations made by Dr. B.R. Ambedkar, and he, while dealing with Article 32, after that article was adopted, he said this is the key to the entire fundamental right chapter and the aspirations of people. This is the most important article in the Constitution. Why? Because it is that right, that remedy which is to approach the Supreme Court for violation of any fundamental right itself was converted into a right under the Constitution and recognized as a right. What has been the advancement of our ethos all over the last about, say, 75 years? If you start going into the first case which was argued by Mr. Venugopal's father, that is Nambiar, he advocated something which is called the ideas flowing from Article 21, right to life, which theory was rejected in the first matter but finally came to be accepted in Maneka Gandhi, and the dimensions are that every individual has a right to have the environment where he will be able to attain the highest potential of his life. That is what we recognize as right to life. If that's the idea, that this is the atmosphere must be created, then shouldn't rule of law also subserve that idea and must be so galvanized, the entire principle of the gamut, that it creates a situation where that attainment of that goal, attainment of that highest potential is the ideal, and that guides us as a lighthouse in all our journey. Now see the development thereafter. Right to life, highest potential, yes. So in Mohini Jain and in K. Unnikrishnan, what did the Supreme Court do? It said that every person has a right to advance in life. And what is the basic tool for such advancement? Nothing but education. And therefore it is the right of every individual to be educated. That is, the primary education is the fundamental right of every individual. Where does this logic come from? The logic comes from extension of the same right which was recognized as one under Article 21. and very important facet of that right which was recognized by the Supreme Court. The recognition came from the Supreme Court first, the Parliament stepped in later and put it as fundamental right as Article 21 capital A in the part 3rd of the Constitution. So who had taken the initiative? The initiative was taken by the Supreme Court. As what? As guardian of the rights of the people. What rights? Rights which every individual has or must have or must be taken to have inhered in himself to attain the highest potential of his life. Where does this come from? This is nothing but Universal Declaration of Human Rights or even our ethos in our Indian culture. Sarve bhadrani pashyantu, sarve santu niramayaha, sarve na sukhina santu, na kaschit dukkham apnuyat. Everybody must be happy. Happy in his individual sphere. And that's where the attainment of the highest potential of his life is something which must be taken to be part of that. Now again, go back to those Dr. Ambedkar's words, that this article is the crux of the Constitution. That is the very article, that is the very power of judicial review, the power to lay down certain principles was invoked by the Supreme Court in Mohini Jain and Unni Krishnan. Hasn't the Supreme Court done time and again? It has done that. Whether it is D.K. Basu, whether it is T.N. Godavarman trying to protect the forest cover in the country, or whether it is Vishakha trying to say that very well ladies or women who are at workplace must be given complete protection when it comes to harassment on the grounds of sexual sort of overtones. This is the other dimension of rule of law. Saying, number one, that everybody must be governed by the principles of law laid down. Yes, normally yes. But at times one has to lay down the principles so that those principles alone will hereafter govern the human conduct. And that's where the Supreme Court has, not only the history of the Supreme Court is that we have not only preserved what is called the individual rights under the codified law, but on a normative plane, on a normative idea, the Supreme Court has gone way beyond that and carved out areas where something like Mohini Jain, that though the statute did not say that, the Supreme Court interpreted it to say that it is part of your fundamental right. Though the statute did not say anything, Vishakha went on to say that ladies must be given this protection. And that protection of rule of law, that protection of the legal principle, the entire legal administration, is something which was afforded by the Supreme Court. So what is the citizen's perspective in the entire matter? We see so many textbooks which deal with rule of law. You will have all those definitions starting from Aristotle, which I placed before you. Then you will have what is called the Athens Declaration of 1955. Then there was a convocation in Delhi in 1959 where about 183 delegates had participated from 53 countries, judges, lawyers, then legal academicians. And then they came out with certain principles, which is normally called Delhi Declaration. One of the ideas is that the laws must be definite. Of course, yes. You can't have laws which are indefinite. That is something, a principle which is also accepted in our constitution, that you can't punish a man for an offense which was not an offense when the act was committed. So the laws must be definite. The laws must apply equally. That's exactly what our Article 14 says. Laws must apply equally to everyone. That's equality as a principle. We have accepted that. The third, there must be a machinery to see that the grievances of the citizens must be taken care of. That's where our judicial review steps in. These are taken to be some of the fundamental features of when we speak of rule of law. But from the citizen's perspective, the assurance that we are not just equal, that the laws will apply equally to everyone, but given the situation, given the circumstances, the courts in this country will not stop and will not tell me that the laws do not prescribe this, so sorry gentlemen, you must go home. The courts may devise something which perhaps the situation or exigencies of the situation may demand, as I told you about this. And it is not just Supreme Court. For instance, one of the high courts, that is High Court of Himachal Pradesh, it came out with a judgment. Justice P.D. Desai, who was then the Chief Justice, came out with a judgment and said that in hill regions the roads must be so given, the facility of roads or the benefit of having the facility of roads is part of your right under 21. This constant, I won't say struggle, but constant endeavor to expand the scope of what is the perimeter of our principles of law is what the citizen is concerned with. He wants not just the assurance that he will be taken care of, the law will apply equally, but at the same time, the courts in India will not stop short of saying that here, if you come out with a particular fact situation, then we may even go to the extent of carving out a niche area, which was done in cases like Vishakha, in cases like D.K. Basu, and so on and so forth. Gone are the days where Justice Khanna was the lone dissenting view, who had to say that very well right to life and the liberty is not something which can be compromised at any juncture. That logic of Justice Khanna now stands accepted in Puttaswamy. And that's the law. So these are certain inviolable principles. If these are inviolable principles, that's where we want to have the protection under the umbrella called rule of law. And that is the citizen's perspective. That is the assurance to the citizen. That is the protection which is afforded to the citizen. And we, as coming from the legal fraternity, are bound to facilitate such protection by every single citizen. Thank you so much.
Thank you, Lordship, for sharing your knowledge and perspective. I would now like to request Honorable Mr. Justice Manish Chaudhary, Judge, Gauhati High Court, to kindly deliver the vote of thanks.
Honorable Mr. Justice Uday Umesh Lalit, former Chief Justice of India. Honorable Mr. Justice Sandeep Mehta, Chief Justice of the Gauhati High Court. Honorable Mr. Justice Ujjwal Bhuiya, Chief Justice of the Telangana High Court. My esteemed brother and sister judges, esteemed Advocate Generals, learned senior advocates and learned members of the Bar, President of the Gauhati High Court Bar Association and other of his peers, members from the electronic and print media, ladies and gentlemen, and dear law students, a very good afternoon to all present. I consider it to be a proud privilege to have been bestowed with the opportunity to express my gratitude, and I am thus honored to be the one making the closing of today's solemn and prestigious function before the august gathering by proposing the vote of thanks. When the idea of a law lecture was considered and conceived of, To commemorate the Platinum Jubilee celebrations of this esteemed institution, that is the Gauhati High Court, no name other than the name of Honorable Justice Uday Umesh Lolit, a man of great legal intellect and one of the finest judicial minds in the country, came up spontaneously and unanimously. First and foremost, I offer my respectful obeisance to see every possible perspective, more particularly from a common citizen's perspective. His Lordship, with his erudite and impactful deliverance, has inspired all on the occasion of the Platinum Jubilee celebration of this esteemed institution, 75 glorious years of existence, and to travel the journey ahead. I express my deep sense of gratitude and my admiring deference to Honorable Justice Sandeep Mehta, Chief Justice of the Honorable Gauhati High Court, for conceptualization, including today's law lecture, and for guiding us at every moment and at every stage in organizing all the programs which are parts of the Platinum Jubilee celebrations of this esteemed institution of judicial excellence. Without his stewardship and leadership at all points, the Platinum Jubilee celebration in such grand magnitude would not have been possible. Events of this magnitude, that is the Platinum Jubilee celebration, of which today's event is also a part, cannot happen overnight. The seeds were sown and the wheels were started rolling months ago. It requires planning and a bird's eye for the minutest details. I am taking this opportunity to express my sincere appreciation and thanks to all my brother and sister judges who have unstintingly given their time, advice, assistance, efforts, and attention in making each and every program lined up during the Platinum Jubilee celebration, including today's law lecture, grand successes. I owe special gratitude to Sri Gautam Borua, Registrar General, Gauhati High Court, Sri Kuntal Harma Pathak, Principal Secretary to the Honorable Chief Justice, and all the dedicated members of the registry who have, in all earnestness, got themselves involved with the Platinum Jubilee celebration programs right from the stage of conceptualization and at every stage thereafter to ensure leaving no stone unturned in execution of each and every program, including today's one successfully. I express my heartfelt gratitude to the Chief Secretary to the Government of Assam and the team of officials of the state government, including the Additional Chief Secretary to the Government of Assam, the Director General of Police Assam, the Commissioner of Police Gauhati, the Deputy Commissioner Kamrup Metro, who have contributed enormously to the success of the program. I am happy to express my vote of thanks to each and every employee and staff of this esteemed institution who have made the program a success. I am saving it for the last, but most importantly, I express my deep gratitude to all the former judges of the Supreme Court of India, Honorable former Chief Justices and Honorable former judges of the Gauhati High Court for their full participation in these programs by gracing the occasions and for their encouraging words. I especially wish to express my heartfelt gratitude to all the former judges of the Honorable Supreme Court of India, Chief Justices former and present, former Chief Justices of this court and former judges of this court who have traveled very long distances beyond the Northeast to be with us these few days. My thanks to Sri Manan Kumar Mishra, Chairman, and Sri Apurva Kumar Sharma, Executive Chairman of the Bar Council of India, for attending the programs. I thank all the distinguished invitees present here for accepting our invitation. I warmly thank all the esteemed senior advocates and learned members of the bar, learned judicial officers, law faculty members, and more importantly, the law students who have shown keen interest in the Platinum Jubilee celebration programs by turning up in substantial numbers. I also express my sincere thanks to the national and local print and electronic media for participating in all the programs, to observe the historical occasion, and for covering the programs in details. My sincere gratitude to all the well-wishers for their blessings and support to the program organized for the Platinum Jubilee celebrations of this unique High Court of 4 states, that is Assam, Nagaland, Mizoram and Arunachal Pradesh. I, on behalf of the Gauhati High Court, like to mention that we are all looking forward for your kind support and participation in the function to be held on 14th of April 2023, in which the Honorable Prime Minister of India has consented to grace the occasion by his kind presence. With these few words, I once again thank you all. Jai Hind.
Thank you, Lordship. Ladies and gentlemen, we are honored to have amidst us honorable judges of the Telangana High Court. We would like to felicitate Honorable Mr. Justice K. Surinder, Judge, Telangana High Court. I would like to request Sri Roman Borua, Registrar Vigilance, Gauhati High Court, to kindly do the honors. Thank you. We would now like to felicitate Honorable Mr. Justice M. Sudhir Kumar, Judge, Telangana High Court. I would like to request Sri Roman Borua, Registrar Vigilance, Gauhati High Court, to kindly do the honors. Thank you. We would now like to felicitate Honorable Mr. Justice Bhaskar Reddy, Judge, Telangana High Court. May I request Srimati Kanchan Newar, Secretary, Gauhati High Court Legal Services Committee, to kindly do the honors. Thank you. With this, we have come to the end of today's program. We would like to thank all of our distinguished guests for gracing the event with their presence and for making the event a grand success. Before we conclude this session, we would like to invite everyone to proceed for the refreshment to the refreshment area. Thank you. Have a great evening ahead.